that there's an accomplice, then I'm
an accomplice without mens rea.
That's correct, Chairperson. Just on one element, yeah. But Chairperson, I'll just read out just some of the concessions that I rely on, some of which are cited in the heads. Let's start with the omission case, so to speak. He considered, Mr. Ramaphosa, that Lonmin should have engaged with the strikers, that had they done so, it was possible that the violence would not have occurred. And that's at page 34693 of the record. He considered that he knew that all the employees wanted was to be spoken to. That's at page 34697. He considered, under cross-examination by Mr. Badlander, that had the approach adopted by Mr. Da Costa been followed, further deaths could have been avoided. And linked to that, he considered in my cross-examination, I even put it like this, Chairperson, to say, let's assume the Fundi and Mabelane deaths were the trigger, the discussion you and I had this morning of the horror. Even at that stage, do you consider that the further 8 deaths would have been avoided had you intervened? And he made that concession. And that's at page 34701. He considered that he was at the meeting of 25 July when there was discussions which probably led to the adoption of the no-talk stance. He considered that he was aware of the issues of police brutality in South Africa. That's 34736, we've already covered that. He also considered that he acted as a messenger for Lonmin senior executive in influencing the changing of the characterization from labor unrest to criminal nature. And he considered that in reality, the root cause of the dispute was a labor dispute. And I think probably one of the last questions I put to him, where he considered that placing of political pressure that results in the killing of people would be unlawful. So, as I said, we have a person who himself really basically says, look, I take personal responsibility, I concede that had I done this, and yet somehow the evidence leaders find something to say, no. Despite whatever he's saying and whatever his concessions, on the basis of legal causation or whatever, there's no evidence, something like that. There's no facts which have been put to suggest that he could foresee. No facts. All these things that we were saying in the cross-examination about the army and what just don't exist. Well, that can be, Chairperson. The job of the evidence leaders is to analyze the evidence. That's why they're called evidence leaders. And the evidence is there. They might say they disagree with the factors that we put, but they mustn't say they're not there. They're there. We raise those issues in cross-examination. And the valuation of those points might differ from person to person. But it cannot be said they're not there. They're there. They were put to the witness. In fact, Mr. Unterhalter interjected exactly when, after putting all these things, I was saying to Mr. Ramaphosa, because of all those things, I'm going to argue at the end that it was foreseeable, that deaths were foreseeable. So it was put in so many words that was the purpose of the... And it can't help to say, well, when it was said to him it's foreseeable, he said, no, it's not. It doesn't work that way. If a witness simply says, I was not there, that has never been a reason for what happens is that the inference of foresight or the foresight is taken from the conspectus of the issues which I've already enumerated. So in all the circumstances, Chairperson, the recommendation for those criminal charges is inevitable. it would take more hard work to find that he should not be charged criminally under the current circumstances. And if it was found that way, it will cause the biggest, it will discredit the whole legal process, really, because it will simply mean that I don't know what needs to be done for somebody who not to be convicted, but to be made to pay. That's what society expects, Chairperson. The criminal law is meant for that there's certain conduct that society has decided must be punished, to put it bluntly and briefly. And that what is called the legal convictions of the community, the expectations, is that the community says, okay, for these and these and these things, you must be civilly liable. It's a private matter between those who wronged each other. But for this and that includes murder and the violation of the most important rights, such as the right to life and other related rights, there must be criminal consequences. And this is the classical case of that. Very quickly, if I can move to the issue of...
Sorry, before you move...
Sorry.
Can you just debate this criminal liability of Mr. Ramaphosa? Yeah. Do I understand you correctly to be saying that because Mr. Jamieson phoned him to say, look, these are the incidents. We've been trying to get the police, can't get them. And because he phoned the minister for the police to intervene, he must have foreseen, or he foresaw, that once the police come in to intervene, death would ensue. Or is it wider than that?
I'm sorry, Commissioner. No, it's much, much, much wider than that. To go back to the chairperson's example of the farmers, if all he had done is what you are postulating now, all he had done, they said, listen, there is this trouble, can you just make this phone call? And just, we can't find the local station commander and so on. No, of course, that's not criminal liability. The criminal liability arises from applying pressure. This is his word, it's not mine. Mr. Ramaphosa says, let us put pressure on them and let them act in a pointed way and so on and so on. And it also arises from the words that are used in the communication. Because by communicating, you're not just committing a crime. It's the content of the words that you are using. And those words are saying emphatically, with an underlining or capital letters, let us ensure that the characterization is changed and we label these people purely as criminals. Remember that whole debate about the hybrid and so on and so on. And the only way this situation can be resolved is by bringing the police and the army. Now, those, apart from the fact that that is wrong to take that approach, as I've said, in terms of the sequencing, the foreseeable consequences of that approach, given the volatile situation, which is why, Commissioner, I was talking about adding petrol to the fire. Remember, there's already a fire. So if you add petrol to nothing, nothing will happen. But if you add the petrol to a fire that's already there of this nature, then we know what's going to happen. So it's the factual complex of these particular circumstances. As I say, let's agree with him to say these people were brutal, barbaric, and what have you, and so on. That alone is what the fire is. So if the fire is like that, you don't then aggravate it by bringing another gang-ho, brutalized, militarized bunch and mix it with this other group of people. That is where the criminal liability arises. And therefore, and that's why the reference I was making to Mr. Jamieson is just instructive. I'm saying, postulate that they were charged together in a common purpose, for argument's sake. Let's say it was Mr. Ramaphosa and Mr. Jamieson. then the fact that he has virtually considered foreseeability, and that's the point you were debating with my learned colleague, means that as far as causation is concerned, it's enough that one of the parties to that common purpose would have foreseen something. That's what the whole doctrine of common purpose is, to cure that, so that you don't have to find it in respect of each participant. Yeah. So, yes, that's the best answer I can give. So it arises from foreseeing the possibility of death. And I'm prepared to say you're not foreseeing 34 deaths, you're not foreseeing big nyalas up and down and helicopters. But if you are saying and the chairperson asked this question, very pointed, well, if you excuse the pun, as a very in a pointed way, yeah. Because he said, the chairperson said, well, explain this. If Mr. Jamieson is saying there's already 800 police there, so it's not the situation which we all know, which was unacceptable of earlier in the week. What is this more pointed way that it can't be anything else except what we saw, which was a massive show of force, bringing paramilitary units and all that what we know. So I'm saying that has got to be foreseeable, or rather, some death must be foreseeable at the lowest.
Okay. The other aspect I don't understand is the liability based on omission. Is that criminal liability you're talking, or civil liability?
No, it's criminal. Criminal liability. And again, thank you for raising that, because what I wanted to say actually is I'm not going to address on civil liability and so on, because a fortiori, if I succeed to convince you on the criminal liability, the civil liability of all the parties mentioned, it follows. But no, it's criminal liability, Commissioner Tokota, because the law on omissions is simply this. The only difference between criminal liability of a commission of an offense and an omission offense is just on the nature of the actus reus, the nature of the human conduct part. The law, in the eyes of the law, it does not matter whether that conduct is done by doing something or failing to do something, subject to the following. If it is the latter, if it is an omission, it must only be where there is a legal duty to act. Now, the duty here, Mr. Ramaphosa, we canvassed this with him extensively, on the omission part, arises not only, it's not the same duty that a General Mbombo would have, because there it's clear, she has a duty as a police officer to protect the community, blah, blah, blah. Here, we're talking about, firstly, his fiduciary duties, his duties as a person is in his position, so to speak, to whom, remember, these workers are entitled to expect that a non-executive director of Lonmin must have their best interest at heart. They can't be expected to think that that person is going to be biased towards the NUM and want to do things and phone this one, phone Mantashe, and phone Baleni, Zokwana, and so on. They can't. They must expect that or to use the expression, qua employees, all these directors are here to protect our interest. So there's a legal duty to act from that point of view alone. But again, from the person that he is. He's a member of the National Executive Committee of the ruling party. I canvassed the connection between the ruling party and the government with him, which he considered. A senior person, and as I've said, a person who is known as a negotiator, a former unionist. All those put together must create a legal duty not to commit the kind of omission. In other words, what I'm saying, Commissioner Tokota, is that, let's say for argument's sake, there was another non-executive director, Mr. Jones, who was also a supporter of that they mustn't talk to the people. He might say, look, this was my first strike. I don't even know what this thing is about. I've never read the Constitution in my life. I don't know what the army does I don't know the difference between the army and the police. So, sorry, maybe I made a mistake. We would believe him. But not Mr. Ramaphosa. We can't. His special position as a non-executive director, as a shareholder, and as a leader. Remember, I said to him, when you were phoning Mr. Mthethwa would not have known whether you are calling him as an NEC member or as a director. And he said yes. And when I asked Minister Shabangu the same question, when you were interacting with Mr. Ramaphosa, was it clear whether it was as an NEC member? She said no. She could not tell. Yeah. And that's the nature of what I call the incestuous relationships. Because remember, there is, to put it nicely, there's not a gang, but there's a group of people in this whole mix who are on the side of Minister Shabangu, Minister Mthethwa, or rather Deputy President, and so on, whose mission in life is to ensure that AMCU is not given the upper hand for the reasons that were canvassed in the evidence. And that is what I was trying to explain. In the conflict of interest arises from that with all these fiduciary duties, you are at the same time associated with the parties who are against, quote unquote, the same workers to whom you owe that duty. For political reasons, because you don't want AMCU to advance and so on and so on. That's a clear conflict because the workers are entitled to expect that you will look after them as everyone. So it's thank you. So on the omission, that's where the legal duty arises. Which takes us very quickly to the question of the corruption charges.
Corruption charges. Can I ask you a question about the suggested prosecution of Mr. Ramaphosa for
Yes.
murder?
Thanks, Chair.
What you said was it arises from the foreseeability of death. That was the test that you propounded. But is it also not necessary to have regard to the question as to whether he foresaw that the death would result from illegal action? Now, we know the police have got power to seize objects from people, so therefore they have the power to disarm. They have the power to disperse people if they comply with the requirements of Section 9.2 of the Regulation Gatherings Act, and they have the power to arrest if they have the necessary reasonable suspicion under the Criminal Procedure Act. So may well have been foreseeable that death might result as a result of police action, but it doesn't follow automatically that those deaths would result from illegal action. So is it not also a part of the test that it was foreseeable that the process he was setting in motion would bring about deaths by illegal action by the police?
Yeah. Two answers to that, Chairperson. The first one is no. It's not part of the requirement. And let's go back to the example that I made. If I set my shop or my house alight, and I can reasonably foresee that there's a hobo who is trespassing on it, then I'm guilty of murder. The fact that the hobo is there illegally cannot absolve me of my criminal liability. Intention in the legal sense doesn't work like that. I know what the Chairperson is saying.
Respect isn't a good one because the death doesn't result from illegal, your example, from illegal action. The hobo happens to be there illegally, but that's a different matter.
Yes.
See,
Okay.
Can I just put an example to you then?
Yes.
Unless you want to give me your second answer first.
No.
Assuming there's a robber in my property,
Yes.
and he's a dangerous robber, and I phone the police and I say, would you please come and deal with the situation? I want you to come because I've got a robber on my premises. And the police come. Now, I will surely foresee that if there's a shootout between the armed robber and the police, either the police or the robber may die. But must I foresee in those circumstances that the police may act illegally? And if that's correct, then whenever there's a robber in my property, armed robber in my property, I dare not phone the police and ask them to come if your test is the correct test, because then I find myself in the dock in a murder charge. Can
no,
that be right?
no, certainly not, Chairperson. You see, Chairperson, a constitutional democracy is something we have to appreciate. Those kinds of arguments were advanced in the case of State versus Makwanyane on the death sentence case. And if you look at all the judgments, particularly the judgment of Chaskalson, it says that
I mean, Chaskalson P.
P, that's correct, Chairperson. Yeah, not my fellow conspirator in physics. The whole emphasis of that judgment, Chairperson, is that the reason why we do not have the death sentence, because that's all that happened to these people. They were executed extrajudicially. So it was applying the death sentence to them without even going to court. Let's assume you've even gone to court and you've had all your rights. The new constitution says that you should not be killed. Why? Because, to come to your example, as the Constitutional Court said, even the worst among us, the worst, they think of the serial rapist, serial killer, serial whatever. Even the worst among us have the right to life. So the fact that there might have been illegal gathering, what have you, with the greatest respect, can never have any bearing on the question as to whether someone who foresees the death of another human being must proceed on the basis that, well, they asked for it because they were involved in an illegal activity. I'm afraid
that's not the basis of my question.
Well,
the basis of my question is whether it's foreseeable that the death would be brought about by illegal conduct.
No, Chairperson, with respect, yes, I hear that. Well, then that goes to to the second issue that I had raised, that one only has to foresee the death of a human being. You don't have to foresee the sequence, the causal sequence, and all the...
The example I gave you of the robber in my house, armed robber in my house, I can't call the police.
Oh.
Because I could, if the policeman comes and there's a shootout between the two of them, and either the policeman or the robber gets killed, I will be on the basis of principle that you argue.
Yes, okay.
I'm sitting in the dock in the criminal court.
Let me explain to you, Chairperson.
Right.
No, it's very simple. It's if the question is, again, you have to postulate the reality. If you know, you're the owner of the house, I'm the robber, and you know that the local police are so sick and tired of robbers that every time they see a robber, they kill them. You know this. Or you have just done a study that shows that these police are so averse to robbery that you'll be killed. And knowing that, as you do, Chairperson, when you see me in your yard, you call the police. Then how can you say you did not foresee that there would be a death? You can't. There might be another basis upon which you might escape criminal liability. But it most certainly cannot be that you did not foresee the death of a human being. It can't.
No, in his example, he does foresee. Yes. He does foresee that.
Yes, he does foresee, but the difference with the Chairperson's example is that one can, it's almost like the weighing of two evils. You can say, well, he does foresee, so either he doesn't call the police or he allows his house to be robbed, as it were. He's in a Hobson's choice situation. Mr. Ramaphosa was not, it's not as if he didn't call the army and the police, the world was going to come to an end. If he didn't call the army and the police, the negotiations were going to take place. So that example is not a good one, with respect. Because here there would have been an element, one might be sympathetic. In fact, as they say, difficult cases make good law.
I think the expression is hard cases
make good law, yes. The hard cases, yes. Bad law. The issue, Chairperson, is that what the Chairperson is postulating is a a moral difficulty. That case would be like S versus Hartman. It would be one of those cases where you would find the chairperson guilty and probably say that till the rising of the court. That's what happened with S versus Hartman, because S versus Hartman, it was said that here's a person who killed somebody else because of sympathy and euthanasia and all that. On the strict test of the law, they're guilty of murder. You can't escape that just because it was a sympathy vote and all that. But what you then do is, having charged the person, having convicted the person, you then say till the rising of the court. That happened in S versus Engelbrecht as well, where Judge Setchwell said an abused spouse has a right to retaliate, even if the threat is no longer imminent in the classical sense of the word, because of the historical abuse. And Judge Setchwell had no choice. I'm sure she would have wanted to acquit the accused, because if you read the 10 of the judgment. But she said, but applying the law as a judge, I have to find you guilty of murder, and then sentenced her to 5 minutes or whatever it is. So the law is the law. It cannot have all these byways. The issue is that if you foresee the death of a human being, more so, even before constitutional democracy, if you foresaw the death of a human being, let alone in a constitutional democracy where the right to life is the most paramount, then the worst that can happen, that must be charged. We're not asking for the death sentence here, or the gallows, or anything like that. We're saying charge. The fact that he might be acquitted in the criminal trial, as it is said in the head, is no skin off the nose of the commission. He might be committed, just like the assailants of Mr. Langa might be charged and they might be acquitted. You can't then say, oh, Judge Falam was wrong. Look, now these people have been acquitted, because that's not the point.
Yeah, I think I understand you.
Thanks, Chief.
You've got, by my watch, about 8 minutes left.
Oh,
so
well,
I'd like you to use them properly.
I will. And by coincidence, those 8 minutes, I'll use it for muti. So maybe they might expand into. Chairperson, before we do that, I just wanted to say the submissions on corruption and so on are in the heads. So I want suffice to say that it's related to the discussion I was having with Commissioner Tokot about the conflicts and so on.
Cross-examine Mr. Ramaphosa
on that, yes, I did, Chairperson, yes. And I can tell you, unfortunately, you can't use the kind of argument that I was one of the authors of the Corruption Act. So I know exactly what it was meant to prevent, and it was this kind of thing. But I suppose that won't stand in any court of law. But be that as it may. Chairperson, the issue of muti, again, with the greatest respect, the muti thing really we should not even take the 8 minutes, because, again, let's come to the evidence. The evidence is very clear. Nobody is denying that muti was used. Because that was done in broad daylight. The only people who deny let me address the murmuring that I've just heard. There are people like Mr. Makidiwana, Mr. Pacha, who say that they did not see the muti being used. That does not mean that they are saying it was not used by anybody else. You see, and there are yet other people like Mr. Nzuza who say they saw muti being used. So, and in fact, if all you needed to do, quite frankly, would have been to call Lieutenant Colonel McIntosh as a witness, and he would have.
What's called as a witness?
Well, no, I'm saying just on this point, yeah. You would have just said to him, go to what happened on the 14th. He will say, my van was standing there, and right in front of me, within 20 meters, there were men who were using a watery substance and so on. It was not a secret. It was done in broad daylight in front of the copy. You know, and it was done at the best count on the papers by something like 50 people. And then I think 50 is probably the lowest, and then there's another suggestion of 200. Let's take either one of those, it doesn't matter. The point of the matter is that the evidence of all the strikers, including Mr. Pasha, that the majority of the people there were not believers in muti, were people who believed in Christian beliefs, like Mr. Pasha, and so on. On any version of anybody, it is a tiny minority, and the most important thing is that they are entitled to it. We cannot judge people by our own upper class standards and say that the mere fact that they believe that muti must be used or is going to protect them is different from other people who believe that prayer is going to protect them. It's the same thing. And so the question of whether muti was used is quite frankly irrelevant to the inquiry that is being postulated here.
So why are you talking about muti? May I say we've been given a document this morning, headed Analysis of Mr. X's statement from an indigenous and psychological perspective, compiled by Ms. Jane Mufumadi. Now, I don't know who gave us this document. Is it SABC?
Yeah, it must be.
SABC document, right.
I think on the doctrine of elimination, it must be SABC.
I didn't know whether
yeah.
it was from
Thank
your
you.
side of the piece.
Chairperson, with the greatest, with the greatest respect, you see, there is, I don't want to sound arrogant, Chairperson, but I don't care what that document says. I don't read these documents. I've not even read that other report of Professor Lamla or whatever. Because so what? Any old professor can come and give us the analysis of the Mr. X's statement. The question here is not what Mr. X believed, or as I've just explained, whether or not muti was used. The question is simply whether, because SABC is looking for a reason why the people were killed. And because there's no apparent reason and all the objective evidence shows that the people were killed unlawfully, they have to find some supernatural explanation. Because how else would you explain? If these people were using muti, that made them believe that they are invisible, why did they stop when General Mpembe stopped them? Why didn't they just walk along thinking he can't see them? I mean, why did they walk on that path avoiding the police towards Nkaneng if they thought they were invisible? Why did they do this and put up and try and duck those bullets? And as Makidiwana said, if you are not scared of bullets, why would you run away from water? Because SABC's version is that they were thrown with water and rubber bullets. And you can see Makidiwana and L206 screaming at the person who's shooting at him from the rubber balls, as we discussed earlier. If he thought, oh, well, firstly, he can't see me. Secondly, the bullet won't penetrate me, he would have somehow strolled through to the slaughter. That's really, please, Chairperson. I don't care however many documents SABC can submit on this. I'm not going to read them because they will not answer the question.
You're not a commissioner, so you don't have to read
them. Unfortunately, yes, I have that luxury, Chairperson. You don't have that luxury. Because those documents are never, that I can put my money on, those documents are never going to say that there is a case that the strikers, let alone those who were there, believed that they were invisible or invincible or whatever it is. Yeah.
You said you were going to spend 8 minutes on muti. I think you've spent your 8 minutes. Are you happy that the muti is not invincible and it's not invulnerable? I'm not happy,
Chairperson. Obviously, the muti is not working because you were supposed to give me more time. Yeah. But Chairperson, to round off, most of the submissions are there. The only important recommendation that I want to highlight is the issue, I think it was raised by the evidence leaders, of assisting in building some kind of monument at the site. I'd like to endorse that recommendation. In the 2 commemoration services that have taken place, that issue was raised quite sharply.
The bishop raised it also in his evidence, remember?
Yes.
Long ago, 2 years ago.
Yes.
Suggested that the memorial should be erected at the site.
Yes.
Be a site which forever would remind people what happened and encourage people to ensure that it wouldn't happen again.
That's correct. And the last one, half a minute.
So that the deceased can be remembered.
That's correct, Chairperson. And again, one has to acknowledge the spirit of reconciliation which the Chairperson commented upon, which was displayed in the most recent commemoration, where all the victims were invited. And I understand some of the other victims, not of the 34, actually attended. I didn't see them, but they told me later. The last point is the recommendation on the International Criminal Court. I know that the Chairperson is not inclined to recommend prosecutions, but I just want to say this. It is done only in this context, in the context that in terms of the Rome Statute, and again it goes to the point of saying we mustn't underestimate the intelligence of people who are uneducated, because they raised this with me, and at first I also thought it was far-fetched. But they kept on saying, what if there is a reluctance because of Mr. Ramaphosa's position or whoever else of the high people, the state versus the state kind of argument? And we then had to do research. And that recommendation is raised in the alternative. In other words, even in terms of the Rome Statute, the domestic court, there would have to be a refusal to prosecute in the domestic courts before it is referred there. And this, I want to leave you with this thought, Chairperson. If, God forbid, something were to happen to President Zuma, then your report will go to Mr. Ramaphosa, all things being equal. So the chances of that prosecution ever...
It's only in the short period after the death that you talked about that you hope won't happen.
No, well, it could be something else, I recall.
But the deputy president doesn't automatically become the president. He acts as president, I think, in the place of an absent president for whatever reason, until a new election, I think, takes place in the National Assembly.
Yes. But yes, no, that's correct, Chairperson. But whatever the theoretical possibilities, whether it's because of a recall or whatever, but the point of the matter is that all things being equal, you would have the person that we are recommending to be accused number 1 being the one who has to decide who is going to be accused number 1. I mean, it's very clear, Chairperson, that is why the clients were quite keen to say what other safeguards, given the dynamics and the dynamics of power of the people involved, high officials, ministers, and so on. It's only in relation to those kinds of people. Obviously, I don't know where the cut-off line would be, but it would be obviously at that level. And so it's only postulated in those circumstances. Chairperson, thank you very much. I appreciate the extra 2 minutes.
Thank you, Mr. Mpofu. Tomorrow morning we will begin with the argument of Mr. Tip.
Yes, I also want to thank my learned friend, Mr. Tip. Thank you.
Thank you for your gesture, Mr. Tip. And we'll hear from you at 9 tomorrow. Commission adjourned.